Welcome to the Mass Torts session. Originating in the US, they're now very well established. In recent years, we have seen a growing number of such claims also being brought on the other side of the Atlantic, here in the UK and in various EU member states. One of the most prominent of those perhaps being the Netherlands. These claims can involve a range of underlying torts and industries, from nuisance claims relating to environmental damages to negligence claims in respect of allegedly defective medical devices. My name's Airlie Goodman. I'm a commercial disputes partner in the London office of Mayer Brown, and I'm one of the firm's co-leads of our class actions and aggregate litigation product group. Today I have the privilege and pleasure of being joined on stage by Rich Moore and Damiën Berkhout, who will share insights about the key issues and trends in mass torts in their respective jurisdictions, appropriately, given the observations I've just made about their jurisdictions, the US and the Netherlands. Rich, Damiën, perhaps you'd like to briefly introduce yourselves?
Sure. My name is Rich Moore. I'm a partner at Williams & Connolly in Washington, D.C. That's our only office. I've been practicing in mass torts and class actions area for over 20 years, representing a wide variety of different industries ranging from pharmaceutical products to consumer products to financial instruments. I've handled cases in both the trial level and in the courts of appeal, in cases in state and federal courts across the United States. Primarily a defense lawyer in this space. Because we have only one office, a heavy portion of our practice involves coordination with other counsel. Both in the United States, we coordinate with counsel in the various states where their cases are pending. And then, of course, if there's a case pending internationally, we coordinate with counsel in those jurisdictions. Another part of my practice involves international arbitration. It's not really relevant, but glad to be here with you. Thank you.
Thanks, Rich. Damiën.
Yes, thank you. Damiën Berkhout. I am the managing partner of the firm Lindenbaum. I'm also head of the class action department. Not practicing law as long as Rich, even though I look older than him, for about 18 years now. Used to be a defense lawyer, then turned over to the plaintiff side in class actions. A portion of my practice is also a bit different, which is post-M&A disputes. There I tend to represent only defendants. We have offices in Amsterdam and in Eindhoven, and very similar to you, Rich, we are also active in other jurisdictions as coordinating counsel. And very deliberately, our firm is only in the Netherlands, because stick to what you know and not to what you not know.
Well, thank you both. And to set the scene and expectations of what we'll be covering today, could I just get you to each give me a very brief definition of what you mean when you're saying mass torts?
Right, and ironically, we're at the class action symposium, but by definition, mass torts, at least in the United States, are cases that are not class actions. There's been a long line of cases dating back really to the asbestos litigation that have held that, in general, personal injury cases are too individualized to bring as class actions, in general. So as a result, in the United States, when you have cases that involve what we call mass torts, which are a single event that results in alleged harm to lots of different people but involve personal injuries, they are brought not as class actions but as mass torts. And the difference is, in a mass tort, you maintain the individual lawsuits from the beginning to the end. Each case has its own separate lawyer, although same lawyers obviously represent many different plaintiffs. But each case is also resolved individually. Whereas in a class action, of course, you have the lead plaintiffs, and they represent the remainder of the class. And the claims are decided collectively on behalf of the entire class, and you have a class-wide resolution. So we're talking about mass torts. That's what I consider we're talking about here.
Thanks, Rich. And Damiën, how does that sit with what you would know of as a mass tort in the Netherlands?
Yes, it's actually quite similar. I must say that the term mass torts is, I think, used very frequently also to refer to class actions in the Netherlands. Mm-hmm. I don't think the term is properly used. I think in the Netherlands the difference is very similar to what Rich described, where either you have a class action and therefore you are in the WAMCA system, or before that the wet collectieve actie system, the predecessor of the WAMCA. And if you're not in that system, you're in the mass tort system, where we generally have 3 models in the Netherlands. We have an assignment model where the individual cases or the individual claims are sold generally to a claim vehicle, or we have a mandate model where the individuals that have suffered harm continue to own the claim, but they provide a mandate to a claimant or claim vehicle to bring the claim, or we have a model where people book build a large group of similar claims that are still individual claims, very similar to what Rich described, but then they litigate test cases on the basis of the group. They try to find sort of the archetype cases within the group and then have test litigation on that basis. The term mass torts seems to refer to a specific type of legal action, a tort. That is also not the case. I think generally when people speak about mass torts, they generally mean mass actions on behalf of groups, and they can also be breach of contract cases. And I think that's not typical for the Netherlands. I think the term mass torts is also used in that manner in most other European countries. So there's a bit of a linguistic confusion, I think, on that part.
From a UK perspective, I think what we mean here, I suspect use our language in a slightly lax way compared to the sort of strict definition in the US, but I think what we're talking about here across all of us is definitely where a group of individuals band together to pursue compensation for a breach of a tortious duty. In the UK, that might be through a group litigation order, a GLO, under CPR 19.22, or a claim under 19.1, where a number of claimants can be covered by one claim form listing their names in a schedule. And these can then, of course, evolve into a GLO on the application from a party, or if the court itself decides it would be more just to administer them that way. And that's what's happened where we've bundled together large groups of claims, such as in the NOx emissions group litigation. I think it might be a stretch to include the representative actions under 19.8 here, but I don't think there's necessarily perhaps the bright line here in the same way as it sounds like there is in the US. Just to clarify, what we will not be covering today in our session is all the CPOs and umbrella claims and other mass claims through which antitrust damages are pursued despite them being brought under the tort of breach of statutory duty. For such discussion, may I commend the audience to tomorrow's specific session on competition claims. And one other caveat for our session today is product liability, which has obvious relevance in the mass torts context, but we're not going to do a deep dive into the specifics there because we don't want to steal the thunder of the next item on the agenda. So back to our session, however, could you just quickly give us a canter through how you actually get a mass tort going, Rich, perhaps from the US perspective? What is the process for handling a mass tort in the US on both a state and federal level?
Right, and that's important, of course, because in the United States we have state level and federal level cases. On the federal level, there are complicated rules about what types of cases can be brought in federal court, but the cases that are brought in federal court are consolidated for pretrial proceedings in something called as a multi-district litigation, or an MDL. There is a panel of federal judges that sits and decides when they have a certain critical mass of cases that are enough cases that are sufficiently similar, they will consolidate those cases before one federal judge who's been appointed to handle those cases. And as I said, it's only for pretrial proceedings. So the MDL judge will get all the federal cases from the country. He or she will decide important issues related to common legal issues, for example, general causation, federal preemption, things that may apply to all the different cases. And those can sometimes be dispositive as a practical matter of all of the cases. But and then the MDL judge will often hold what we call bellwether trials or representative cases to try to determine the value of the cases. But there is a Supreme Court decision that says that the MDL court cannot actually try cases that have been transferred in from the other federal jurisdictions. So at the end of the MDL proceeding, the cases get sent back to their home districts for trial. So that's a little bit of a quirk about the MDL procedure. But the MDL is a very, very important part of U.S. civil litigation. As of February 2025, there were 164 MDL proceedings involving 278,246 cases. Over 95% of MDLs have more than 1,000 cases. And some people have estimated that as high as 65 or 70% of all federal civil cases in the United States are in MDLs. So it's a very substantial part of the United States docket. Now, on the state side, as again, there's complicated reasons why certain cases can't be brought in federal court, and those remain in state court. And there are certain jurisdictions in particular that are very attractive for plaintiffs for various reasons. And there are cases, jurisdictions where you have very high verdicts, not as stringent of gatekeeping requirements on scientific testimony. For example, Philadelphia, New York City, Cook County, Illinois, California State Court, St. Louis, Missouri, and so you'll have a federal MDL proceeding and you'll have a parallel proceeding in state court that will have just as many cases, if not more, in most mass torts. And the state courts can create their own little MDL for proceedings within that state, and they can also choose to coordinate with the federal MDL, although it's not mandatory.
And Damiën, how about from the Dutch or EU perspective?
Yeah, so the interesting thing is that in the Netherlands you don't really have a different procedural regime for mass tort cases. So you're in the normal regime, which of course presumes that you have a single case. There are two ways where there's a workaround. The first is to either have an assignment or a mandate, and then in essence you bundle the cases and litigate them as a group at the same time. Now, very similar to the US, you still need to assert and substantiate damages causality on an individual basis. Although I must say, in practice, if you gather a very large group of 15,000 people in a somewhat similar situation, the courts tend to look at things a bit more abstractly in practice, although formally these are all individual cases that are being litigated at the same time against the same defendants. A second development that we've seen in the Netherlands is that courts increasingly, at their own volition, have decided to bundle similar types of actions at the same time. In fact, courts have tended to send group action cases that have been filed in a particular district to another district, very similar to what you see in the US, saying, well, it's better if all those cases are served by the same district court. We can have an interesting debate whether or not Dutch law provides for that, but it's a fact of life that it does occur, and I think it's a very good development. So, for example, in the trucks case, you can see that the Amsterdam District Court has gathered up all of these different trucks cases. I think by now this involves over 600,000 trucks that have been purchased, and not counting the indirect purchases that have also brought trucks claims. And the District Court has done a case management where they have created different waves to deal with these cases. And I anticipate you will see more of this case management in the future. And it will be interesting to see whether or not the legislator also intervenes and provides a separate regime for these types of mass torts. Although I actually think it's not necessary, because it tends to work. Specifically when you're dealing with assignments, so where the claim has been transferred to a claim vehicle. That works very well in practice in the Netherlands. Frankly, I see no reason for a separate regime, because it simply works. Looking abroad to some other jurisdictions where our firm works in, I see that there are very vast differences. Like some firms we work with in certain jurisdictions, which I shall not name because they perhaps prefer to remain unnamed, they simply say it doesn't work. It doesn't work here. And what you then see is that there is form shopping. So increasingly we see that cases are being brought in Portugal or in the Netherlands, where a claim vehicle can bring effectively the claim on behalf of people also residing abroad.
Really helpful, good to know. We're now going to take a look at the key updates and development trends we're seeing in mass torts across our three jurisdictions. From a UK perspective, I think the most significant trend has been very much the use of parent company liability to establish the jurisdiction of English courts over claims that otherwise have no UK nexus. In particular, mass claims for environmental damage being brought here in the UK, despite the damage having occurred elsewhere as the result of an act or omission committed elsewhere by a foreign entity, with the damage suffered by claimants not in this jurisdiction, and the relevant underlying law being that of a different jurisdiction. We've had a line of cases establishing that despite this lack of UK nexus, such claims can be brought in the UK against a UK parent as an anchor defendant on the basis that the UK parent company has exercised a sufficiently high degree of control, direction, oversight over the foreign subsidiary so as to have assumed a duty of care to the claimants that had been breached by the subsidiary's act or omission. I'm thinking here of Okpabi and Shell and, of course, the Mariana Dam case. Thank you to the High Court for being something of a warm-up act for today's session last Friday. Those are perhaps the highest profile examples. More recently, in Limbu and Dyson, our Court of Appeal appears to have extended the reach of this concept further, confirming that a UK entity which allegedly asserted a high degree of control over the manufacturing operations and working conditions of its foreign supplier might be held liable for torts arising from alleged acts of modern slavery by that supplier. Now, as I just alluded to, we have just had here in the UK this last Friday judgment in one of those very high-profile mass tort claims, Mariana Dam case, the Fundao Dam collapse, which was brought by over 600,000 claimants against Australian miner BHP, where BHP, through its UK parent company, has been found liable in the UK despite not being the direct legal owner of the dam that collapsed in Brazil. Now, in that decision, the judge found, applying Brazilian law, that BHP was responsible for the polluting activity due to their control and operation of San Marco, which was the owner and operator of the dam, which BHP 100% owned in equal shares with its JV partner, Vale. Now, BHP has said it will appeal, and quantum will be determined at a further hearing yet to be scheduled, but the litigation has been valued at up to £36 billion, or $48 billion US dollars, if that's the currency you think in. The broader implications of this decision for mass torts more broadly is still under analysis and perhaps deserving of its own panel discussion in due course, but unquestionably it will be encouraging for further claims to be brought on the basis of parent company liability in the UK, so certainly one to watch. Now, Damiën, I understand that there's been a similar trend from your perspective in the Netherlands?
Correct. Yes, we've seen this development for quite a time. First of all, we of course have the concept of undertaking competition law cases. And from that, we increasingly see that the Dutch courts are willing to at the very least accept jurisdiction on the basis that there can be parental liability. In fact, I believe it was last week that in a case against 3M, a US company and a Belgian company, the Dutch courts accepted jurisdiction on the basis that the US company was not acting independently from the Belgian company, and that sufficed for the courts to establish jurisdiction. That does not mean that these companies are also liable, because I think 4 weeks ago, in a case which is based on somewhat similar principles as the Mariana Dam case, that the Dutch court has accepted jurisdiction, but it also found the holding company, not liable on the basis that there's no strict liability under Brazilian environmental law, which is interesting because I think from a material law perspective, the Dutch courts seem to feel different about Brazilian law than the UK courts perhaps does. But on the jurisdictional point, I think you can see very similar results, and that's clearly a trend, a trend which I think is something that we will only see increase in the future, because the step has been made from competition law to non-competition law cases, and I believe it will also move further beyond the tort cases to contract cases, because the real test appears to be by these courts, is there a measure of control? Is it the case that the holding company is directing certain behavior? And from yeah, I would say I feel that courts are very pragmatic and think, well, it shouldn't depend on the legal basis you're bringing your claim, shouldn't define whether or not there's jurisdiction or not.
Yes, I agree. It does seem to be a rather pragmatic approach and perhaps expansive of the jurisdiction. Rich, perhaps you could take us through some of the most interesting developments you've been seeing from a US perspective in mass torts in the last year.
Sure. In the past several years, we continue to see these very, very large mass tort matters being brought in the United States and very well publicized. And the first one I want to flag was the 3M earplugs litigation. And these were when servicemen and women brought case against 3M alleging hearing loss from defective earplugs. And this was the largest ever MDL in the United States. Involved several 100,000 cases. And as I described earlier, it followed sort of the typical path that you see in a mass tort. They were consolidated in the MDL. There was a series of bellwether trials, 16 trials. The plaintiffs won 10 of the 16 with about $300 million in verdicts. There was one $77 million verdict. And so after you see these series of verdicts, then you see a settlement. In August 2023, 3M agreed to a $6 billion settlement, and that sort of working its way through the system. So that's not so much a current case that's on its way up, it's one that's sort of on its way down, but sort of a case study in terms of how these very large cases happen in the United States. There's also the Johnson & Johnson talcum powder litigation continues to be a very large mass tort proceeding in the United States. Those are cases involving alleging that J&J's talcum powder products cause ovarian cancer, mesothelioma, and other cancers. There have been some very high verdicts, including one in October of this year for $966 million, $16 million in compensatory damages, $950 million in punitive damages. So there are about 58,000 of those cases pending in the federal courts, plus at least as many cases pending in state courts. And then there's the PFAS litigation, polyfuracil litigation involving film-forming foams, and those are cases allege environmental contamination in groundwater. And there's about 8,000 of those cases, and those cases are being brought by individuals seeking personal injuries as well as states and local governments seeking to recover for environmental damages. And there have been some settlements last year, but there's still many of those cases pending. One of the other areas that is a particular hot topic in the United States are what we call non-traditional claims, in particular public nuisance claims. So traditional nuisance law is under the common law, I think, and certainly in the United States, has traditionally involved property damage. So if you have someone pollutes your property, you can sue for abatement of damage that's caused to your property. The plaintiffs have begun to bring what they call public nuisance cases and product liability cases. In particular, in the opioids litigation, the state and local governments claim that the costs to the state and local governments of treating the patients for these opioids was a nuisance, and the company had to pay for that. And the reason those cases are being brought under that theory is because it makes it easier to overcome some of the individualized issues that you have in a traditional product liability claim. Someone could say, well, it didn't really cause your condition, or you did something else to cause a condition, whereas it's harder to say that state or local government had those individualized issues. So there was a case in the Fourth Circuit in the past month where there had been a trial where the trial court judge had concluded under West Virginia law that this public nuisance doctrine was not viable. The Fourth Circuit Court of Appeals held that under West Virginia law it was viable, or at least need to go back to trial to be considered. So that's a significant new area. And other, of course, other types of product liability cases and mass torts are also pursuing and carefully. That case was particular to West Virginia, but there are other cases, for example, there are cases being brought in consolidating California relating to teen and adolescent addiction as a result of social media. The claims are that these social media platforms have caused teens and adolescents to become addicted, has affected their mental health, and so they're being brought as individual claims on behalf of those individuals, but they're also bringing these public nuisance claims on behalf of state and local governments for treating those plaintiffs. Mm-hmm. So that's something that's developing in the United States. As far as rule changes, there's one rule change that's scheduled to go in effect in December of this year. It's the first ever rule that we've had for MDL proceedings in the Federal Rules of Civil Procedure. You'd think with over half the cases being MDLs, we'd have a rule on it, but this is the first time they've enacted that. It's a pretty bland rule, frankly, but it establishes some procedures. But one of the big hot-button issues in the United States with regard to mass torts is that at the end of these mass torts, so it's very easy to file a case in the United States. You don't have to do anything but pay the filing fee, and then you go into litigation. If you're in a normal individual case, the court would have a case management conference. You would sit down and you would talk about, you'd have to present some evidence, not much, but at the beginning of the case, unlike in, I know a lot of European jurisdictions where you have to put a lot of evidence up front. In the United States, it's the opposite. The evidence is not much evidence or essentially no evidence to file the case. All of it very much weighted towards the end of the case at trial. So you have this big period of discovery, and then then you have the trial. So in a normal case, there's some screening mechanisms. The judge will talk about, put into place a discovery schedule for that case. In a mass tort case, these cases get filed all over, and they get sent to the MDL with no screening mechanism at all. And so there's a saying among the defense bar, at least, that build it and they will come. So once you have a mass tort, once you have an MDL, you get this massive influx of cases. And so what we found is that at the end, when the cases become resolved, or if there's ever a requirement, many of the plaintiffs not even take the product or weren't exposed to whatever the alleged harm was, let's just say, or they did not suffer the alleged injury. But there was no screening mechanism. So the MDL rule, after a lot of debate, it's a very, very weak rule, but essentially what it requires is that the MDL judge at the beginning of the proceeding should hold, as part of the initial case management, should consider how the parties will exchange information about the factual basis for their claims and defenses. So it seems like probably the most basic thing that you would expect in any kind of litigation, but surprisingly it's not there in MDL litigation. So what's interesting is because the rule is so broad and so non-specific, it's really going to depend on each and every MDL judge to decide how they're going to implement. So I think that'll be very interesting to see how these MDL judges interpret that rule and whether or not they do place a more stringent screening mechanism at the beginning of the MDL as opposed to at the end of the MDL.
That's very interesting to hear that such a rule is still being introduced in a relatively developed regime. And also to hear it from the birthplace of mass tort, some of the recent developments in particular areas, although the social media claim does make me slightly nervous as the parent of teenage boys. But it also draws out for me one of the broader trends that we're seeing, not just in mass torts, but across collective actions more broadly in the UK, and I think also in Europe, of generally seeing claims that are perhaps particularly successful in the US being translated across into the UK and into European jurisdictions as well. I mean, some of those cases that you've just mentioned, the earplugs and the talcum powder litigation, are now being mirrored across in very nascent stages here in the UK. Not quite there yet with PFAS-related claims, although every indication seems to be that it's only a matter of time, particularly as we see increasing headlines around the high levels of contamination in water and in particular towns, for example, Bentham up in North Yorkshire, which has apparently expressed some interest in bringing a claim on behalf of concerned residents and businesses, given the high concentration of PFAS in their groundwater up there. But Damiën, I understand there's been some developments in courts finding that they expressly do have the competence to hear PFAS-related claims, which suggests that it's probably a trend you're going to see as well.
Certainly, and I also agree with you that it's still very much the case that matters are filed in the US and then they slowly but certainly they sail towards the UK and then they tend to end up also in other jurisdictions in Europe. And these can be PFAS cases, but these also often are competition law cases, other mass torts cases. We tried to take stock a while back of how many of these cases are actually resolved in Europe. And it is interesting to see, and I think we should be self-critical on this point, that you can see that many of these cases are settled sooner in the US, faster in the US compared to Europe. And there's a dichotomy there apparently between cases which are copycat cases and which are actual cases that are filed in Europe first. So what you can see is those cases tend to settle sooner. That's interesting, right? So I do think that there is something in copycat cases which tend to take longer, at least according to the data that we found as a firm, and that might be an effect of the fact that cases can be filed quite easily in the US. So some of these copycat claims in Europe, in my view, are being filed way too swiftly. Right? These cases do not take into account that in Europe, or I should say more succinctly, in the Netherlands for sure, when you file a writ of summons, you need to provide evidence with your writ. And if you try to file something on the basis of what is a claim form in the UK or something similar in the US, it's quite difficult to properly substantiate your case. And then you're in purgatory as a plaintiff, because then the defense can use that against you and draw out a lot of defenses asserting that you need to provide more evidence, etc., etc., etc. So I think that's one of the things you can see in terms of trends. In terms of other trends, to come back to your previous question, I think we're not supposed to talk about product liability cases, but in the background, many of those cases are going to come up in 2026 because of the new directive, of course. The second thing that we've seen is there's been a very interesting decision in the TikTok matter by the Court of Appeals where, and I should in disclosure said that I helped file that claim in the past. So as expected, of course, the courts eventually decided at the Court of Appeal level that you can bundle immaterial damages. So in response to that, I expect that many more GDPR cases, which were quiet for a while because there was concern whether or not you could bring and bundle immaterial cases, I expect those to be coming up against. And in the meantime, because there was some uncertainty about whether or not you could bundle those cases, we actually saw that many of these GDPR cases were being filed as mass tort claims. So instead of class actions, people tended to go to the court, sometimes summary proceedings, asking the court to order the company to cease and desist with, for example, placing cookies. And if you don't do that, you have to pay penalties. And that was a very interesting business case, because if you do that for a couple of thousand cases, these companies cannot comply because their entire business is structured about providing cookies. And we've seen, I think it's a bit hidden for a portion of the market, but there have been thousands of these cases being filed to attempt to get the penalties rather than actually getting the company to stop and cease and desist with those cookies. And finally, I think what we have also seen in terms of trends is settlements. So there's been the diesel settlement, the Woeker-Polissen affair in the Netherlands, which took over 10 years, but they've been settled in the last year, increasingly so. Not all of them, but most of them have been settled. The same applies to diesel, I should say. In diesel, there's been a settlement for a particular model, but many diesel gate cases are still ongoing. The state has settled for the child care benefit scandal. And I think that that's a good sign that you can see. I think in the previous panel, it was remarked that settlements are a sign of a healthy system. I think that that's a very good sign that we can see the settlements lately coming up.
That's really interesting from my perspective, and particularly picking up on what you were saying about the sort of data breach, privacy cases. I think from a UK perspective, because there's been such mixed success here for claimants in that area, the well-publicised cases in Lloyd and Google and Prismal and Google really making a prohibitively high bar to bring them as representative actions, with some more success perhaps under GLOs, particularly I'm thinking here of the British Airways settlement a number of years ago off a 2018 data breach. But also we of course have in the CAT, which I was trying not to mention, the Gormson and Meta case, which does again give claimants access to the opt-out bells and whistles that would tend to make those kind of claims more economically viable to pursue, and perhaps is a really good example of the attractiveness of to claimants of framing their claims and in an antitrust context to get access to that particular regime. I think that one of the final topics we wanted to touch on briefly, particularly in our two jurisdictions, perhaps of less interest in the States, Rich, is litigation funding, which has been such a hot topic here in the UK in recent years, sparked by the Supreme Court judgment in PACCAR and then the subsequent workarounds that the bright minds of the claimant and claimant firms and funding community have come up with that have been approved by the Court of Appeal, and of course the recent recommendations of our Civil Justice Committee in terms of reversing PACCAR by legislation, but also seeking to recommend the introduction of a new regime of light touch regulatory controls. It's one of those things where from the defendant's perspective, which is my perspective, a bit different from yours, Damiën, the light touch recommendations that have been made, which we remain to see how they will actually be implemented by the government, will certainly be welcome in terms of some of the safeguards and guardrails that would be introduced, particularly with respect to cost protection for defendants. Now, while we don't yet, at least, have the routine scrutiny of funding arrangements in the UK mass tort regimes in the same way that we do with CAT CPOs, funding has been something that has come up for us in these claims, particularly in the context of defendants seeking security for their costs directly from funders. And this is not yet something that's been fully litigated here yet. The Knox litigation has taken it the furthest, with claimant solicitors there actually managing to avoid disclosure of their funding arrangements by arguing that the provision of adequate ATE insurance to cover the defendant's costs would mitigate the need for such disclosure. But certainly developments in this area, I think from a defendant's perspective, would be very welcome. But I understand, Damiën, that things are developing as well in the Netherlands. Do you want to touch on that briefly?
Sure. So in essence, if class action systems in the Netherlands, the WAMCA, there are actual rules, right? There are rules which the courts also tend to apply, and those rules are not very substantive, and there are not many, but there are a couple of clear principles I think you can really already see in case law. One of them being that if the funding fee is too high, the courts will, well, they will prod at it and will ask the plaintiff to explain why the number is so high. In particular, I think a very good approach by one of the district courts has been to say, if the percentage you get as a funder is up to 25% and there's no objection, we will let the case continue. We will not say that that's a fair number. That's something that we will decide at the end of the case. But up to 25% and no objection, that suffices to continue to have standing as a claimant. If you're above 25%, then you have to explain yourself, even if the defendant does not object. I think that that's a very good approach, especially for consumer cases, because that provides a measure of protection for the class. I am very much in favor of litigation funding, simply because it's a fact of life that many of these cases, especially class action cases, would not exist. So there would be no access to justice especially if you have mass tort cases with very low damages on a per individual basis. If we move to the actual topic of this panel, which is mass torts, there are much less regulation. Frankly, there's contractual freedom. And I think that should remain the case. As a company should be able to fund its own activities, I see no reason why a damaged class should not be able to fund its litigation if they want to assert that they've suffered harm. Why should there be a different regime for that? There are voices that say, well, there should be disclosure of those funding arrangements. I mean, a defendant also is protecting itself and funding its defense. There should be no disclosure of that either. So I think I don't really understand the reason why the plaintiff side should provide disclosure of its funding arrangement if the defense doesn't have to do so at the same time as well. And frankly, I don't see any reason to introduce new rules because I haven't seen, well, misuse of the system. I understand that there are always stories that the system is being misused. I challenge people to provide me with examples, show me your examples, and then I would be the first to say we'll need to fix this system, but I haven't seen them. And I think for this reason, the Dutch courts allow funding of cases, also of mass torts cases. And I think a very fundamental decision that has been taken in, for example, the air cargo cases, the trucks cases, is that the courts have acknowledged that it's possible to sell your claim to a claim vehicle on the basis of that you will pay out the person that suffered harm, be that a company or a person, in the future, depending on the outcome of the case. Right? Accepting that made many more cases possible because there's no cash out at the front end for the funding. And if you would oblige people to pay at the front end, it would be much more difficult to bring these mass tort cases, I think, in the Netherlands at least, and I think in many countries. Perhaps turning back again to your last question, interestingly enough, what we've seen in the recent 2 years, increasingly so, funders have decided to pay at the front end for these cases, which is, I think, a sign that they really believe in those cases because they're willing to put money up in front. And that's also a measure of the funding scene becoming more adult, I would almost say, because the reason that they're doing that is also because there's more competition, right? If you say to somebody, I want to purchase your claim and I will pay you in 5, 6, 8, or 10 years, that's a hard sell. And if you say to somebody, I'm going to pay you now, that's an easier sell.
I think from my perspective here in the UK, from a defendant's perspective, the mere proliferation of funded cases and some of the speculative, if not unmeritorious claims that may have been brought, which are nevertheless eye-wateringly expensive to defend, really has made it make sense for what the government has recently done, which is look at whether the litigation funding model that has been permitted to facilitate the access to justice that you've just referred to, does it remain fit for purpose as it's continuing to evolve as it has done in response to the way that class actions and mass torts have developed in the UK? I'm very conscious of the time.
Can I respond to that very quickly? Because there certainly are cases that are being filed everywhere in the world that don't have merit. That's a fact of life, I agree with that. But that's a very bad investment for a funder. So ex ante, it's not very likely that a funder would fund a case that doesn't go anywhere. And at the same time, there are also cases that are being defended that have no chance of succeeding the defense, right? The only victory can be then delay in that case. So I'm not very convinced that the mere fact that sometimes people file bad cases is not necessarily an argument against litigation funding. It's an argument for better education, right?
And I think the argument that you've just made has been very much what has underpinned the self-regulatory approach that we've had in the UK. But I think now is a timely moment to reflect on whether that is actually what, at least in the UK, we want to continuing to be what governs the way that this is going to be developed. I suspect we will continue to disagree agreeably on the point, perhaps. But I'm very conscious of the time, and the clock is now aggressively blinking at me. We are more than happy to take questions over the lunch break. I understand that the product liability people are volunteering to do the same, happy to club together with them and answer mass tort and product liability questions all at once. So hopefully we'll see you over the lunch break.